Good afternoon, sir. I know you've already been previously advised in your prior arrangements, but I'm going to formally advise you now. You do have the right to remain silent concerning these new charges, and the statements you make could potentially be used against you in court. You have the right to plead not guilty to these charges and went to trial in front of a judge or a jury. You have the right to a public and a speedy trial. At a trial, you may confront and cross-examine the witnesses against you, summon witnesses, testify on your behalf, and offer any defenses you might have. In any criminal trials, the state's burden to prove you guilty beyond all reasonable doubt. You are entitled to have counsel. If counsel has filed a full appearance on your behalf. As a person held in custody, you're entitled to reasonable bail set by the court. You should also be aware that if you're not an American citizen, sir, you run the risk of upon conviction of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. If you have any questions about your constitutional rights, speak to the court now or confer privately with counsel. You understand your rights, sir?
I do.
All right. Madam Bail Commissioner, good afternoon. What else can you tell me, please?
The defendant is 52 years old. He's lived in Connecticut for 19 years. He reports that he is self-employed for the past 15 years as a builder. He has 15 years of education. 2 pending matters out of this court that come back January 9th. The first matter is for tampering with physical evidence. He posted a $500,000 surety bond. The second matter is for tampering with physical evidence and hindering prosecution first, where he posted a $500,000 surety bond. He has no convictions on his record. I would recommend a $3 million bond with a condition of IPS and CPS, that he do not leave the state of Connecticut without permission, that he have no contact with the co-defendants, his minor children, and no contact with the minor children through third parties.
Judge, Attorney Jen Guinness is here. She filed an appearance for Mrs. Farber and the children, is the victim's family. The clerks have a protective order that I'd ask you to order also as a condition of the defendant's release. As far as bond goes, Your Honor, I believe that the bond is set by the court at $6 million is appropriate in this matter. I would ask that you order that the defendant makes bond, that you keep the IPS, GPS with house arrest, and any conditions the court deems appropriate. Additionally, I'd ask that you enter the protective order as a condition that he have no contact with Mrs. Farber or the children through third parties or himself, and any other conditions that the court deems appropriate. Thank you.
Before I hear your bond argument, counsel, are you, I know you're an experienced practitioner, have you had a chance to review the proposed protective order?
I have not, but we're aware of the nature of the order and its practical effect.
Therefore, I will give you, I'll formally issue it upon arraignment. What's your bond argument, counsel?
Judge, we think that $6 million is excessive. We're asking for a bond of $1 million. And here's why. Mr. Dulos was arrested in June of this year and that fact set before the world that accused him effectively of murder. He made a $500,000 bond, was fully compliant with the court's orders. Additional charges arose after additional evidence took place, again charging with hindering and making what we think are extraordinary allegations about what state police believe and so forth. We waited for months in anticipation for this warrant, wanting to see whether these beliefs would be produced or supported by fact. And the warrant we read last night offers us perishingly little that differs and advances a new theory of the case. Prior to yesterday, the motive was Mr. Dulos did this to extinguish his wife to end a bitter divorce. Now it's to gain control of the trust fund. The case is actually charged in the alternative. It's either murder or it's felony murder arising out of a kidnapping. As to the strengths of the state's case, I think the state is still groping in the dark, grasping at straws, and it has thrown now a dart at Mr. Dulos, which has landed. He has been fully compliant with your orders and is out, or was until yesterday, on a $1 million bond. We received information from a credible source that he was about to be arrested. I traveled to his home, arriving before the state police, and brokered a friendly transaction. It was tense and sorrowful, as you can imagine such a thing would be, but he cooperated even there. Although he has substantial ties to Greece and family, he's known now throughout the world thanks to the publicity of this case, and I suspect 80% of the folks in the courtroom are reporters. There's a bank of cameras, the likes of which I've never seen outside the courtroom. This is an extraditable offense. going to be on house arrest with GPS and electronic monitoring. I do not believe him to be a flight risk. He has been compliant with the orders. There's been but one dust-up with respect to the electronic order, the electronic monitoring. I believe he crossed state lines at some point in the area of New Bedford. I may be wrong about that town, but upon investigation, probation determined that that was inadvertent on a twisting state route. So we think an additional $1 million bond is sufficient. I can count on one hand the number of cases in which I've seen the bond larger than that in my career over the last 30 years involving murder, and those were typically for gangbangers or people directing criminal enterprises. The state believes he engineered and caused his wife's death. We don't. We're anxious for the trial. We're relieved by the allegations in the warrant. If that's all the state has, we're confident about trial. And Mr. Dulos has no interest in flight. He has every interest in fighting this case and reclaiming his reputation. So we believe an additional $1 million reflects the seriousness of the offense. That would yield a cumulative bond of $2 million. And so our request is for a $1 million bond.
Sir, listen carefully. I'm issuing the following protective order because the nature and circumstances of this murder qualify this as a family violence crime, which allows the court to issue this protective order. And it will remain in effect until further order of the court. So with respect to the protected parties, that includes GF with residents in Manhattan, as well as 5 minor individuals whose names I'm not going to read, but whose names and dates of birth are on this order. With respect to all of those parties, you are not having any contact with those protected parties in any manner. That includes by writing, electronic, or telephone. No texting, no Facebook, no social media. Do not contact their home, workplace, or anyone else with whom contact would cause them annoyance or alarm. You must stay away from the homes of the protected parties and wherever they may reside. Do not assault, threaten, abuse, harass, follow, interfere with, or stalk the protected parties. You must not possess any firearms or ammunition. So if you are in possession of any firearms or ammunition under the terms of this protective order, such items have to be surrendered or transferred to the Farmington or State Police, as the case may be, while this order remains in effect. You have to stay 100 yards away from the protected parties. So, do you understand all the different terms of the protective order, sir?
I do.
Will you obey it?
I will.
Give a copy to the defendant. If you have any questions, please speak to your attorney or talk to family relations. Well, counsel, I'm well aware of your position as to the disappearance of Jennifer Farber Dulos, the mother of your client's 5 children. Your arguments as to his lack of involvement in Jennifer's disappearance have not changed since his first arrest for evidence tampering last summer. However, what has changed since then is the new charges of murder and kidnapping and related charges which bring him here today. In addition, the quantity of the evidence against the defendant and his exposure to incarceration in the event of a conviction have all gone up substantially. And the nature of the bond is to ensure appearance in court. And the amount of the bond must also match the gravity of the offenses charged. I believe that the bond at $6 million is appropriate. In the event your client does post that bond, he is to remain under house arrest during the pendency of these proceedings, IPS and GPS monitoring. He has been compliant with his GPS monitoring according to the Office of Adult Probation. I expect that to continue. He is to not leave the parameters of his home without permission for Jefferson Crossing address, except for medical appointments, church services, and meetings with defense counsel.
Judge, we discussed in chambers the potential for his obtaining approval to leave the premises for work-related purposes. I don't know whether you have considered that and rejected it or if that was inadvertent.
State's position?
I think similar to the co-defendant, Mr. Mawhinney, Your Honor, I don't believe it's appropriate.
Well, on a case-by-case basis, but I think that the danger is the exception could swallow up the rule because he's an independent contractor, as I understand, and you could argue a trip to Home Depot would be something work-related. So I'm going to make that on a case-by-case basis, but if I feel there's been any abuse of the condition, I'm going to have another hearing where I will impose more strict conditions if he does post that bond. So, sir, bottom line is you not have any contact with the co-defendants, obey the protective order, don't leave the state of Connecticut without permission, surrender your passport, take medical appointments, church services, meeting with counsel, and work-related appointments and visits are permitted under this, but
With prior approval, Your
on
Honor?
the prior approval of the supervising probation officer, I believe in your case, it's a Mr. Jeffrey Coffey. So that is the court's order. I did speak briefly to counsel. We've agreed upon a new date.
Judge, before that,
Yes.
I neglected to ask that he also have no contact with the nanny that's been with his children, Lauren Almeida. So if we can make that a condition of his release also, not to have any contact with her.
But we would object to that insofar as it may apply to us as his agents. She's a witness, and we may well reach out to her.
They can reach out and she could say, I don't want to talk to you, but I don't want attorney, I believe your Honor could order that Attorney Dulos, Mr. Dulos not have any contact with her, and that's what I'm asking for.
I understand the distinction, I think, that you're fine for us, but yes, Attorney Kattis, I'm not trying to prohibit you from mounting a defense to these charges, but your client is not to have any contact with his children's nanny or home nanny. So ordered. February.
Your Honor, we talked about February 28th as a continuance date. I spoke to counsel about waiving the HPC. They indicated they don't want to waive it or not able to do it today. So I'd asked that any continuance be charged to them, and I'd asked that Mr. Dulos' case that was down for the 9th be continued to the February 28th date.
Yes, sir. As your lawyers undoubtedly advised you, because you're now charged with murder, it does carry the constitutional right to a hearing in probable cause. That has to be held within, I believe, 60 days of your arraignment unless there is a request for a continuance which is chargeable to either party. I'm not requiring you to make that election today, but because of the charge, probable cause hearing must be held and within the time frame. Is defense counsel asking for the continuance?
We are.
All right, so the date of
February 28th.
February 28th.
In Part A, please, Your Honor.
In Part A, all further proceedings to be in Part A, the Stanford Judicial District. That is so weird.
Thank you, Your Honor.
Thank you.
Those are all the matters I have, Your Honor.
Any further business to come before the court?
No, sir.
All right, this court will stand adjourned.
All rise. Court standing adjourned. Everyone